Okay, let's dive into this explainer. Today we're unpacking a really heavy but absolutely crucial reality. We're talking about the deeply ingrained flaws within our criminal justice system and the legal frameworks that are, well, supposed to hold it accountable. We're going to look at what actually happens when the very machinery designed to uncover the truth instead actively buries it. It's a fascinating and honestly sometimes heartbreaking look at the intersection of human error, systemic failure, and federal law.
2,622. According to research compiled by the National Registry of Exonerations, that is the staggering number of documented exonerations in the U.S. since 1989. Let that sink in for a second. But what you really need to take away from this is that this number, it only represents the people who actually managed to clear their names. It doesn't even begin to count the unknown thousands who are still out there, suffering in silence with their freedom stripped away for crimes they simply did not commit.
To make sense of this whole complex issue, here's our roadmap for today. First, the anatomy of a wrongful conviction. Then, how the system fails. After that, we'll look at when officials break the law, followed by fabricated evidence and perjury. And finally, the path to exoneration.
Section 1. Anatomy of a wrongful conviction. The staggering scale of the problem. So how exactly does an innocent person end up spending decades behind bars? Well, the data gives us some pretty startling answers. Up through 2014, misidentification played a role in nearly 75% of all exonerations. That's huge. But it's not just honest mistakes either. In 2018 alone, a record 107 exoneration cases involved official misconduct. We're talking about things like concealing exculpatory evidence or even threatening witnesses. What you're seeing here is a real matrix of failures: eyewitness misidentification, totally inadequate legal representation, and deliberate official misconduct.
Section 2. How this system fails. Misidentification, misconduct, and inadequate defense.
And this brilliantly illustrates the reality on the ground. To truly understand these statistics, we've got to look at the human case studies. Look at Francisco Berra, for example. He lost 8 years of his life because his defense team failed to provide English translations for tapes where the actual gunman basically admitted to the crime in Spanish. Unbelievable, right? Then there's Michael Evans, who lost 26 years to a life sentence despite having his initial conviction vacated due to prosecutorial misconduct. And Marcus Lyons, whose absolute nightmare involved an incredibly biased police lineup and untested evidence.
The timeline of Marcus Lyons is it's particularly visceral. He was sentenced back in 1988 because the state relied heavily on a highly traumatized witness rather than just pursuing blood tests that were readily available at the time. After he was released from prison in 1991, the psychological toll was so severe that he literally attempted self-crucifixion on railroad ties. I mean, that is just tragic. It wasn't until 2007 that untested DNA evidence finally cleared his name, and then 2012 when he reached a $5 million civil rights settlement. This right here is the profound human cost of these systemic errors.
Section 3. When officials break the law. The federal statutes governing misconduct. Now, you might be thinking, isn't it strictly illegal when police or prosecutors lie to secure these convictions? Let's take a look.
So, when you hear about police hiding evidence or coercing confessions, let's look at the dense legal framework meant to stop that. The cornerstone here is 18 U.S.C. Section 1001. This is the General Federal False Statement Statute. It essentially dictates that any statement made knowingly and willfully to deceive the government, whether it's an official falsifying a report or an investigator concealing facts, is a serious federal crime. And get this, you don't even have to be under oath for this to apply.
But there is a very specific catch. For a false statement to be punishable under this statute, it has to meet the standard of materiality. What this means is that the lie must actually have the power or the natural tendency to sway a decision. Now, what you really should take away from this is that it doesn't matter if the decision-maker actually fell for the lie. Not at all. The simple fact that the lie was capable of influencing the outcome, that is enough to break the law.
Then we have perjury, which is covered under 18 U.S.C. Section 1621. While Section 1001 covers those general false statements, perjury is much more specific. It requires the offender to have taken an oath before a competent tribunal and to have acted with deliberate, willful intent to deceive regarding a material matter. So think of it as the difference between lying on a police report back at the precinct and lying on the witness stand during a federal trial.
Section 4. Fabricated evidence and perjury. The escalation of police misconduct.
Now, what's really interesting about this slide is how these statutes actually collide with the alarming reality of misconduct.
We see it in the sheer variety of ways evidence is manipulated, as documented by civil rights firms like Brustein Law. When we talk about evidence fabrication, we aren't just talking about a forged signature on a document. We are talking about planting evidence, falsifying timestamps, coercing false confessions through intimidation, and, perhaps most commonly, concealing exculpatory evidence. That's evidence that would literally prove a defendant's innocence. Every single one of these actions is a profound violation of a citizen's constitutional rights.
So, let's look at how this applies to building a legal defense. Here is the vital legal distinction. A Section 1001 violation, like an officer falsifying a forensic result on his desk, does not require an oath. But perjury, Section 1621, like an officer lying on the stand, absolutely does require an oath. But here's the kicker. Securing a perjury conviction is notoriously difficult because of the historic two-witness rule. This rule means the falsity of the statement has to be corroborated by either two independent witnesses or one witness and some really strong corroborating evidence. As outlined by the Congressional Research Service, the federal government does take these violations seriously, well, at least on paper. Violations of these statutes carry some pretty severe penalties. Under Section 1001 and Section 1621, offenders can face up to 5 years in federal prison, and if the matter relates to terrorism or federal sex offenses, that penalty jumps up to 8 years, alongside some massive fines. So the legal tools to punish misconduct absolutely exist, but actually applying them to the criminal justice system itself, that is a massive hurdle.
Section 5. The Path to Exoneration. How Victims Fight Back.
When innocent people lose years of their lives, how do they claw back their freedom? So the crucial point is that regaining freedom isn't just a single event. It's honestly a brutal three-step war. Step 1 is exoneration, just getting the false charges dismissed so you can walk out of prison. Step 2 is pursuing civil and constitutional rights violations. This means going on the offensive to hold the specific agencies and officers legally accountable for breaking the laws we just talked about. And finally, Step 3 is compensation, seeking financial justice for the lost wages, the emotional distress, and the sheer trauma they endured.
But getting that compensation is essentially a geographic lottery. Right now, 35 states have what are called exoneration statutes that offer automatic financial payouts for time served. Though, to be fair, these are often strictly capped. But if you happen to be wrongfully convicted in one of the other 15 states, you have to pursue a civil rights claim. This forces the victim to bear the heavy burden of proving that unconstitutional conduct, like intentional evidence fabrication, actually occurred. And let me tell you, that is incredibly difficult to win in civil court.
Well, we've covered the human tragedies, the data, the complex federal perjury laws, and the steep uphill battle for compensation. All of this leaves us with one unavoidable, provocative question to end on today. When those sworn to uphold the law are the ones breaking it, who pays the ultimate price? It's a heavy thought, for sure, but understanding these structural flaws is the absolute first step toward true justice reform. Keep asking questions, keep looking at the data, and we will see you in the next Explainer.